Welcome back, everyone. So continuing from the previous two panels, we have yet another panel to take forward some of our discussions on abortion rights. And many of the questions, I think, will continue. So we look at transnational reproductive rights activism in this panel. And we have a wonderful, kind of global set of speakers. One of the speakers will be joining us online. And I think what really has struck many of us over the last few months is the recent decision of the US Supreme Court in the Dobbs judgment, where it overturned Roe v. Wade. And that made us question not only, not only looking at where abortion rights go from here in the US, and we've been following a lot of the developments in the US, but what it also means to abortion rights and reproductive rights generally in other parts of the world. What kind of an impact will this decision have on reproductive rights? What kind of an impact will it have on many other rights that were kind of, relied on by the US Supreme Court and other courts as well? Will it turn back many of those rights? And then, and if perhaps that is the case, how do we, as activists, as legal scholars, as practitioners, how do we go forward? And, taking one of the questions that came up in the last panel, what are some of the tactics or the strategies that we can adopt to go forward? Do we use, the quiet mode, as one of our speakers said, to look at law reform? What are some of the softer tactics that can be adopted in the light of some of these decisions which are such a blow to reproductive rights constitutionally? Just laying out the ground, I'll go on right ahead with the speakers. We have our introductory speaker, Alicia Yamin from Harvard University. She'll be joining us online. We also have our other speakers, Mette Lakeland from the Auckland University Hospital. We have Satang, who's joined us earlier. And we have Kirigo from the University of Pretoria. So one more speaker who was there is not going to be joining us, so we do have a little more time, and hopefully we'll be able to take on some questions. So excited to start off this panel. I'll invite Alicia to join if she's here. Welcome, Alicia. The floor is yours.
Thank you. I'm here. Can you hear me, or is there an echo?
Yes, we can hear you.
Can you hear me?
Yes, we can hear you.
Okay, well, I again wish I were there in person. I was able to hear part of the earlier session, which was really spectacular, and I wish I'd been there to ask questions. After talking with Siri and Jana, I think it would be useful to try to do four things really, really quickly. One is to set out the context in the United States. The second is to talk a little bit about jurisprudence on abortion from Roe to Dobbs. The third is to say a few things about the Dobbs opinion itself. And then the fourth is where we go from here. Jana, can you hear me well, or is there an echo?
No, it's perfectly fine. Please go ahead.
Okay, I hear the echo.
Yeah.
Okay. So in terms of the US context, not everybody is that familiar with the United States. The first thing to say is that the normative universe on which we draw to construct abortion rights is quite different than in many other countries, right? We have a constitution that is the traditional, possibly the archetypical liberal constitution of the 18th century, which is very spare. The interpretations of rights have been quite narrow and formalistic, and our constitutional structure really, or interpretation, has been remarkably impervious to the growing interpenetration of international concepts, which I think makes it different from some of the other contexts that we'll be discussing later on. and I can say more about that, but that's important to keep in mind. Our political system is a very, very well entrenched two-party system. It's famously anti-democratic in terms of the way the electoral college works, but it's also undemocratic in a couple of other ways. One, 85% of the population lives in half of the states, which gives a small number of senators at the federal level that come from deeply conservative states, a very strong voice in political policy. At the state level, there's constant redistricting and, in fact, gerrymandering, where how the districts to elect state representatives are changed. Both parties have been actively engaged in that, but I would say it's fair to characterize the Republicans as having been more active. So what does that mean? Even where states where there are large progressive populations, they're often captured in one district instead of having their effects multiplied. They are either diluted through a lot of different districts or held in one so that their actual effect is underrepresented. That's important to keep in mind. The third thing to keep in mind is our health system, which is kind of a patchwork based largely on employer-based insurance. The state is a gap filler, not really a universal provider. And most abortions in this country are performed outside of our regular health system. So those are three things that make, I think, advocacy in other places somewhat different than in the United States. On jurisprudence, Roe v. Wade was decided in 1973, along with a West German case. It's often pointed to as sort of one of the leading cases in this field. Roe did a couple of things. First of all, it was based on an earlier case on contraception, Griswold versus Connecticut in 1965. It did a couple of things. One, it set up a trimester framework, and two, it established a viability line where a woman had reasonable discretion before viability, say around 24 weeks. And then after viability, when the fetus theoretically could exist on its own, the state has a far more compelling interest in protecting that unborn life. It's fair to say that Roe has been criticized from the outset. It's really not as much a decision about feminism and gender equality as it is about deference to medical professionals. Black men had been counsel to the Mayo Clinic previously, so it had been criticized on those grounds previously. The second thing to say is that the legal entitlement was not matched by effective access to abortion care for a great number of people, largely poor women, girls, and people, pregnancy-capable people of color. There's always been a big gap there. There's something called the Hyde Amendment that says federal monies don't need to be spent for abortion. That was held constitutional in a case called Harris v. McRae in 1980. So that gap between legal entitlement and effective access is important to keep in mind. In 1992, there was another very important case called Planned Parenthood versus Casey, which essentially reaffirmed the central holding of Roe about viability, but said that before viability, the states could regulate abortion if those regulations do not impose an undue burden on the woman's fundamental rights. That has been variously interpreted. There are a number of different cases on ultrasounds, parental notifications, trap laws, which are called targeted restriction of abortion providers. Some circuit courts found targeted restrictions of abortion providers as restrictions on the abortion providers, without seeing that in practice those had effects, those imposed a burden, because they shut down clinics, imposed a burden on women seeking abortions. So it has been extremely intensively litigated. In the mid-1990s, right around the time of Casey, but also at the time of the transsectoral UN conferences, a reproductive justice movement began in the United States from Black feminists who realized what I just said, that the gap between legal entitlement and effective access is deeply racialized as well as class-based. And that reproductive rights movement, the pioneers of that, Loretta Ross, for example, would say that it had deep consonance with international frameworks. Reproductive justice is more about ensuring that men, women, girls, pregnancy-capable people have the structural conditions in place to allow them to make the decision about when and whether to have children or not to have children, and to raise those children. So much more of a holistic, interdependent, multiple conditions and rights involved. So that was more or less of what was going on until, with different circuit courts deciding this undue burden test, until 2016, the Supreme Court, with an opinion by Justice Breyer, attempted to impose some parameters on how to apply that undue burden test. That opinion was then essentially reaffirmed in 2020 in a case called June Medical Services, where very similar legislation, fact pattern from Louisiana. And in that case, Chief Justice Roberts, who had dissented in Hellerstedt, concurred because of this concept of stare decisis, that really this presented the same legal issues. The court had decided this way a few years ago, so he concurred. So what changed between 2020, June Medical, and 2022, Dobbs? Well, the personnel on the court changed, right? Public opinion really didn't change. Nothing else changed besides the personnel on the court. So when Alito takes the extraordinary decision to throw out a 50-year-old super precedent, there have to be some kinds of justifications for that. And he says there hasn't been any reliance interest. Women don't rely on the ability to have terminations if they're getting pregnant, which is actually not true, as any woman will tell you. The conditions have changed. Amy Coney Barrett was really pushing this, like, you can get pregnant and you can drop off your newborn wherever. I'm sure some of you have seen on the internet these drop boxes that look like mailboxes in conservative states that are for newborns to be dropped off anonymously. And most primarily, the decision was so egregiously wrong from the outset that it had to be overturned. And to get to that, the court adopts what is called originalism, which is kind of odd for a lawyer that's not from the United States, and even for some lawyers from the United States. I do not adhere to originalism, but the idea is, and I'm not going to go into this, it's complex. Some people talk about original intent, some people talk about original meaning. It was actually initially an idea of a liberal justice, Hugo Black, to rein in the court from eviscerating labor protections. But the idea of originalism is essentially to say, well, these are unenumerated. Abortion was based on privacy, which was rooted in the Due Process Clause of the 14th Amendment. It as part of ordered liberty under the 14th Amendment, it's not an enumerated right as the first 8 amendments of the Bill of Rights are. Freedom of speech, for example, freedom to bear arms, for example. So if it's not an enumerated right, is it deeply rooted in our tradition? And they look to the original, theoretically, they look to the original meaning of words, and and what was going on at the time. Fixes the meaning of legal documents at the time. So Alito picks through selectively, as has been pointed out by very many commentators, our history, and says, no, it's not deeply rooted in American tradition. And at the time the 14th Amendment was enacted, which is 1868, it was widely criminalized. Now, of course, if they couldn't find more explicit mentions, the people who they are looking to the plain meaning of words from are men, are white men, right? So that abortion was not specifically mentioned is not surprising, and the practice of abortion could be found in our history in many, many places. And I'm happy to answer more questions about originalism and why it's problematic to look back and fix the meaning of ordered liberty from a very narrow subset of people to what our society looks like in the 21st century. So what now? Well, there are a couple dimensions to that. One is what do we know has already happened since June 24th, and probably about 22 million women, girls, and pregnancy-capable people have lost access to abortion in this country in a little over a month. It's not going to go back to pre-Roe because most abortions in the United States are conducted through medication abortions. But there's a lot of contestation about those medication abortions. The FDA has issued some guidance about sending pills through the mail. There is litigation challenging that guidance now. There will, I am anticipating, be litigation over questions of what are called preemption. So there's federal legislation that is called the Emergency Medical Treatment and Active Labor Act, which was enacted to prevent patient dumping from one place to another, and specifically dumping of women in active labor. I think there will be litigation about how that's interpreted. I think there will be litigation about HIPAA. HIPAA is federal legislation around privacy for patients. And weaponizing health systems against women who may be having obstetric emergencies, who may be having ectopic pregnancies, who knows, will make questions about HIPAA arise. And I expect, well, I'll just leave it there. But then there are referenda on the ballot. There are elections that are centering abortion issues now. There are motions to create state legislation both to protect abortion as well as to create fetal personhood in state constitutions. So it's quite a patchwork, and it's legally chaotic. I advise Partners in Health, which works with partners doing clinical delivery. It's very complicated for providers to know what they are entitled to do as a matter of legal right and not risk their ability to practice medicine. In terms of other rights in the United States, the same reasoning, the quote, substantive due process under the 14th Amendment, it was the reasoning that was used in Griswold in the contraception case. It is the reasoning used in Obergefell, which is the same-sex marriage case. It's the reasoning used in consensual sexual practices in the privacy of your home in the Lawrence v. Texas case. It has been used in a number of different, a wide array of different cases. So, and we have yet to see what that is going to mean. Clarence Thomas wrote an ominous concurrence saying that substantive due process is an oxymoron. And that's not just a Thomas view. That has, again, there's a strong current of judicial activism. As I heard about judicial activism yesterday when I listened into one panel But there's a strong current of, as Learned Hand would say, we don't want to be ruled by a bevy of platonic guardians. So there's going to be a lot of activity politically, a lot of activity in social movements. I did mention previously that the kind of liberal feminist autonomy plan was quite separate from the reproductive justice movement. We're seeing some movement together now among social movements, but I would say that the feminist movement in the United States is still quite fractured, and there's also an element of transphobia. So there are these cleavages and we have not done one of the things that was absolutely done, for example, in Argentina. I don't know if it's been discussed, to really socialize the issue of abortion much more broadly as participation in society, as a gender equality and democracy issue involving labor movements, etc. And I think that goes back to, one, how the health system's set up, two, how what the normative universe to draw on is, and how the health system works. So that's also going to be quite different in other countries. I anticipate that this Dobbs decision is going to have an effect, sometimes through courts. It may unfortunately have an effect on a case that's going to be heard by the Brazilian Supreme Court eventually, and it may have an effect in Central America on the Inter-American Court. I'm doing an amicus in a case at the Inter-American Court that should, potentially could establish a right to abortion. I think it will largely have an effect through politics. Kenya just elected somebody who's extremely Christian conservative, who knows who is going to be elected, but I think it will encourage conservative populists to use abortion as a way of distracting from political economy issues, for sure. And I'll stop there. I'm sorry, Jane, I might have gone over.
Yeah. Thank you. That was fabulous, and I think you really laid out the entire kind of gamut of all the developments in the U.S. and kind of sets the tone for the panel. Satang, would you like to go next? And
sure.
Because I think what we'll do is we'll go with Satang and then Mette and then Grigo at the end.
Great.
Yeah.
Okay, thank you. Thank you, Alicia, for setting the stage. I'm sure people are going to be tired of me soon, but before they do, I have been in, I think, quite a lot of conversations, when the decision was leaked and then when it was issued by the Supreme Court, in terms of the implication of the Dobbs judgment, especially on countries that have, in the past drew inspiration from Roe. I think, not to speak for Africans and those from the global south, I suppose, but I think in a sense, the Dobbs decision really illustrates the success of the Trump administration and less of the sound judicial reasoning, but that's me, so anyway. And I also think that in terms of the edition itself, it's the regressive development that we've seen is also in sharp contrast, I think, to the previous panel, both that focused on Latin America, but also Africa as well as India, in terms of the progress that have been made, and we sort of already discussed that. But I think, and I did briefly mention this, I think partly what we've seen, especially in terms of the conversation around what will be the likely implication of, the Dobbs decision on the rest of the world, since if the US coughs, everybody has to move, in a sense, I think is really the realization that, for instance, that we've seen, as I said, the rise of conservative movement that really shows the interlinkages, transnational linkages between organizations that are based in the global south and organizations based in the north. I think recently we've seen quite a lot, and I think one of the key things that really comes out of this is that there is is a less focus on just abortion rights, and more it is like a focus on the plethora of sexual and reproductive rights. So we are talking about comprehensive sexuality education, which we see in Kenya, which I'm sure Kerigo will talk about, as well as in Ghana, but also, I mean, Adrian is here and works on LGBT issues. We've also seen the bill that has been tabled in Ghana, and these are all part and parcel of the work that has been done and the transnational linkages between these two organizations in the various continents. And I think in a sense as well, it's just also acknowledging that whilst we see the rise of this, perhaps it's because, you know, we've seen this in court-centered strategies, we've seen this in legislative strategies, but also we've seen it even in college campuses. For instance, in South Africa, we have the Student for Life at the University of Cape Town, and we've seen you know, materials that are actually garnered from the US as well as in other places. But also acknowledging that these interlinkages is also not new, right? So we know that from the 1990s and the early 2000s, there is the transnational linkages between these actors as well. I think for me, and I know that we don't have a lot of time, I wanted to focus on, for instance, one of the questions that is part of the really a crux of the panel is in terms of how the work can move forward. And for me, yesterday, I think I raised the question around funding and how to reimagine that was part of the health governance panel. But I think it's also, you know, and very much in line with the theme for today and the keynote, is in terms of thinking and acknowledging, for instance, the influence of neo-colonial foreign assistance that we've seen that is very much linked to the curtailment of sexual and reproductive rights generally. So we've seen that even though donor organizations and donor countries will give funding to low-income countries in Africa and elsewhere, that this doesn't really address, for instance, and provide for adequate sexual and reproductive rights programs, including access to abortion services. But I think partly as well is, even though rightly so that we're pushing for aid recipient countries to be able to set their own national plans and their own national agenda, I think there needs to be sort of like a push as well in terms of the focus not just being on addressing unsafe abortion and on complications, but rather on actually providing services for safe and early abortion in these various countries as well. Just quickly on strategies, and I wanted to just perhaps highlight one on research. I know we're talking a lot, and Kerigo will also talk a bit about that, on understanding the organized resistance towards sexual and reproductive rights, but also the transnational linkages. Whilst there have been a bit of effort in terms of that, the literature and the work has mainly been from the global north. I think, especially in terms of what the, you know, the reproductive rights movement can do, is really starting to invest more and dedicating quite a bit of time in terms of understanding the organized resistance. What do they draw on? What are their linkages? Where does the money come from? We need to follow the money. As I said, Open Democracy have done a little bit of that, but we do not have adequate information as to how much money flows from the north to the south in terms of the work that is currently being done. And just quickly, in terms of misinformation, I know a question was asked earlier. Some of the, especially in terms of the peddling of misinformation, for instance, include linking you know, abortion to cancer, and we all know that there is no viable evidence around that. But those are things that are being used that are actually discourses and materials from the global north organization, conservative organizations that are doing this. So my point is that there is little knowledge about organized resistance in the continent, and as well as their linkages, and there needs to be more, especially in terms of supporting activists on the ground, in terms of the resistance work that that they do as well. Am I still on time?
You have 1 minute.
Okay, okay. So the other thing I also wanted to highlight, obviously, it's with regard to my research agenda or project, which is on conscientious objection, which obviously is very much evident in South Africa because of its different legal framework, but also acknowledging that, you know, there is a lot of traction around that work as well in Latin America. So I think part of strategies as well is not just about conversations going from the south to the north, but from South-South as well, I think is important, especially in terms of thinking beyond just regulation, which is great because Latin American countries, especially the Colombian Constitutional Court, has amazing jurisprudence around that. But how do we go beyond regulation to thinking of what sort of research and activist strategies can we undertake in terms of pushing, for example, healthcare providers that don't want to provide abortion to move them and move the needle in terms of that. I'll stop here. Thanks.
Yeah. Thank you. Mette?
Well, first, thank you for the invitation. Being a medical doctor, and this is a new setting for me, this type of discussion. So I'm a gynecologist and also a feminist activist, and worked with abortion for 25 years. Also the medical advisor to the abortion registry in Norway. And I was kind of saddened first by what was the text that was following this panel, talking about the backlash. Of course, it's not. I don't agree, like been said earlier, that this is a backlash that it's affecting the whole world. It's a backlash that's affecting the United States, and of course that could also affect the rest of the world. But there's also, like it's been said, a huge advance in abortion access all over the world, or many parts of the world. And also, what I find very interesting at the moment, because we have just started a debate in Norway on a new abortion law, and the Commission started the work yesterday, is that new wave of kind of the second wave around of abortion rights that you've seen in New Zealand, in Australia, in Iceland. Finland is about to increase their rights. Kind of laws that is actually following the actual practice. And as a medical doctor, the legal framework is, of course, very important, but it's also very important how you actually access abortion. That's why, for instance, like the representative from Ethiopia was talking about Ethiopia, who's had a good access to abortion, while Zambia, even though they have a better legal framework, has very poor access. I think it will be interesting to see, because what we have seen, to tell what's been happening in Norway the last 10 years, is that our conservative government have tried to limit or to pull back on the access to abortion. But what's happened then is that there's been a huge public discussion are following that, because the people don't accept it. So they're actually kind of, I don't think they were thinking that that would happen. So what's actually, after those 10 years almost with debates, what's happened is that the political opposition have decided to now change the law to increase access to abortion. So I do believe it's very, it was one of the questions, should we debate this, or should we do it like behind the scenes? Or I believe in picking up the debate and have a huge public debate, and it's very important that all take part in that debate. And it's important that we don't let those conservative religious sides take the lead in that debate and decide what the court and rules for that debate should be. So constantly, for instance, like when I was on TV yesterday and they want me to talk about things, the viability of the fetus, and I always have to change. I said, that's not the question here. The question is the right to choose, the medical progress, etc., and make sure that I set the rules for the debate when I'm on TV or in other debates. And I think it will be interesting to see what will happen in the US, because of course in comparison to El Salvador and Poland and Nicaragua, which are the only other countries who had a backlash, is that they have kind of one law in the whole country, while of course the United States is a diversity of laws and access. And I think that will also influence the debate, and maybe actually the political parties and political agenda would finally step up and talk about abortion, because they haven't. It's just been a right that's been there, and it's kind of only Hillary Clinton, I've heard, that's actually talked about abortion rights among politicians. And also, so the response from the FDA when the High Court didn't close the Texas law to lift the restriction on medical abortion, I think it's other ways of making sure that access could be there. And of course, the future for abortion treatment, that is to take a phone call, have a consultation, and have the medication sent to you. There are multiple studies that show that that's equally safe as having to see a doctor, and it's equally safe to have it done by a nurse or a midwife. So that's the future for abortion treatment up to 10 weeks. And in Norway, 92% of all abortions are done before 10 weeks. So improving access in those ways is also important ways of getting around and organizing the health facilities. But we have also another question, which is, I think it's interesting in a legal setting like this, in Norway, is that Norway has abortion on request up to 12 weeks. And that's really been decided through the public debate that that's non-negotiable. Then after that, people have to pass to a commission of 2 doctors who will tell them if they can have an abortion or not. And 99.5% of all those abortions are granted. But we have the absolute upper limit which says in the law when the fetus is viable. Of course, when the law was written, it was 28 weeks. Now they lowered it to 22 weeks. And the artificial womb is just around the corner. So what will happen then when you have an artificial womb? Because they've also decided that viability is when you get all the medical treatment that a prematurely born baby would get. And I think it's very clever of the Australians and in New Zealand that they have excluded the limit of, or the question, and probably also Argentina and Colombia, that they haven't put viability in the law. And I think that would be very important for any country that should rewrite to take that out of the law or to not include it. Well, and then of course also to join forces. And one of the things I think it's lacking in Norway, I would know that I have all these legal people discussing law, to have, because that's actually lacking in Norway. I don't see people within that field taking part in the public debate. And in Norway, of course, in countries where you have poor access to abortion, I think it would be a good thing to go after the health, to look at the access, the right to health. That was also how we initially got the law in Norway. But then when you, like in Australia and Norway now, the next step will be the right to autonomy, which is, of course, also is dependent on the right to autonomy you have in any other part of the health system or in the country. And I would love lawyers in Norway to come forward and debate the same access to autonomy within the health system for women who are pregnant, because you have the right to decide what will happen to your body after you die, but you don't have the right to when you're pregnant. Yeah, I'll pick up.
Thank you. Perfect timing, and finally, Karigo.
First of all, let me say thank you very much for the Law Transform family for making this possible. So I'm going to answer this question by explaining how the anti-gender, anti-SRR movement is currently operating. First of all, they studied us, they understood us, and they are in the process of perfecting the game. Unfortunately, unlike us now, they don't play by the rules. They really don't care what they're going to lose. and they're in it to win it. I'm going to explain this by giving an example of what is happening in Kenya and in Africa in general. So we must understand that the anti-gender, anti-SRHR movement is not new. This is something that has been documented in Africa from as early as the 90s, where we had the American Center for Law and Justice setting up offices in Nairobi simply to make sure that Kenya doesn't get the 2010 constitution, because the constitution, the current one that you have, provides for abortion, right? Access to abortion services. So as early as that particular point, they were very, very clear about their agenda. They are here to make sure that they limit sexual and reproductive health rights, especially abortion, and the rights of LGBT persons. So now what we're seeing is that they're more organized, they're well-funded, and it's transnational. And what they're doing, especially in Africa, is that they're no longer sending people from the global north to be the face of this movement. They're using local actors. Citizen Go has this very, very loud person who's very active in terms of misinformation, disinformation. She's always all over the place, and she's based in Kenya. However, you will find her today in Malawi, Zambia, and the agenda is the same. We will make sure SRHR is attacked on all platforms. And yes, we're discussing about abortion today, but they have this approach where they attack abortion, they attack CSE, they attack issues around adoption. There are very many, they have a multi-pronged approach. So I feel like it is time that we now have to learn from them and perfect the game. Why do I say this? So in Kenya, for instance, these people have gotten to a point where they are actively financing politicians to sit in parliament. These politicians sponsor bills, or they shoot down bills that are meant to protect sexual and reproductive rights. So for quite some time now, aid meant for SRHR or international INGOs, when they provide funding for sexual and reproductive rights, they usually have this provision where they say funding is not supposed to be used for political activities and all that. But for how long can we stay neutral, or can funding stay neutral of political affairs? If the other side is using that avenue, these conditionalities that come with aid that is geared towards SRHR, such as non-political activities, is it really sustainable? The other thing that they are also doing is a principle, or it's an approach that they call catch them young. So catch them young is what Satang also mentioned about targeting the school-going category of people, students. And in Kenya, they're using very nice and beautiful languages like mentorship programs, leadership and governance. But if you look at the principles, if you look at what these people are being taught, they're very radical approaches to sexual and reproductive rights. So it comes in a package that me and you would not be able to tell if we just glance over it. But if you look at the ethos of these programs, these kids are going to leave school very, very radicalized, and they're going to be advancing an agenda that is not going to be safe for us. And then they've also gotten to an extent where they're building their own universities. We have Strathmore University is quite known, it's quite famous, but the principles, the teachings of the university are quite Christian-based, and they have been in fact, the current, the Law Society of Kenya, the Law Society of Kenya, the current chair, is also very actively engaged. Wait, is it? No, it's not Law Society of Kenya, sorry. But we know that some of the people within the legal fraternity in Kenya also operate within this framework, where now this anti-gender, anti-SRHR movement are not only just using advocates, right? They're also using professionals. They're using lawyers, they're using doctors, they're using teachers, they're using psychologists. And through this professionalization of anti-gender and anti-SRHR rhetoric, they're getting more legitimate within society, because if you see a doctor giving false information or misinformation about abortion, people are going to believe it, because not very many people are going to interrogate what the doctor is saying, and, oh, the doctor has said. So we must also make use of professionals within the space. And then lastly, I'm going to talk about their use of media, both mainstream and social media. They are good at it. They are organizing symposiums, they're organizing conferences, they're always on TV, giving false information, they're even manufacturing their own data and statistics. So we must make sure that as we think about advancing the sexual and reproductive rights agenda, we must move away from the traditional approach that we have constantly relied upon, which many people on the grassroots level find very elitist. We must take the conversation to the grassroots, because that is where the social currency is. And now that is what the other side is doing. The agenda is being owned locally. Meanwhile, those of us who are pushing the sexual and reproductive rights agenda are looked at as people who sit in boardrooms, people who are elitist, who have access to a particular sphere of influence. So we are looked at as outsiders. So we need to find a way of making sure there's ownership from the ground all the way up. Otherwise, we will still be having this conversation, if not a much worse conversation in a couple of years. We must learn from them and beat them at their own game. Yeah.
Thank you. We have about 10 minutes for questions. Is that fine? I think the session is to finish at 1:30. So if we can take a few inputs, questions, comments, we may have some time. Yeah.
Suggestions.
Yeah.
Just line up here.
Maybe we can take a few questions and then kind of...
Okay, thank you so much, and thank you to the panel. I just want to make a few comments on some of the things that you've said. Amit spoke about debate, that we should be having a debate. That's a good thing, except that there are some places, again, like my colleagues have said, that you may not be able to have a debate. In my own country, Uganda, right now, it's quite difficult to have a debate on abortion because the other side basically owns the debate. In fact, they have gotten to a point where they seem so comfortable, like there's no opposition whatsoever, that their position is what is right. And if you come out and speak out quite plainly, then the consequences are not so good. So, for example, we are having a case right now in court challenging the abortion laws to decriminalize abortion. And since the decision in the US that Alicia spoke about, we are asking whether we should actually continue with the case, because we are relying on Roe versus Wade a lot. And if it's now gone, then what are you relying upon? In fact, we are in court around, just before that decision was made in the US, and the judges were laughing at us. Like, you want to decriminalize abortion? Like, really? Are you serious? Yes, this is what we want. So now we are asking ourselves, if we had that decision in the US before, now the decision is not there, what happens? The case is at the stage where we have to make submissions. Whether we are done with submissions, we are awaiting decision. And we are thinking, should we withdraw this case at this moment? So, very important conversation is happening right now, and we have really to think about the broader implications of the happenings that are elsewhere. Thank you.
Thank you. This is a fantastic panel, and two points, right? And just to pick up on Adrian's, I think there's a really important set of issues about legal scholarship, right? And kind of the examples that are looked for, how it's taught, how abortion law is taught, and it kind of comes back to things that Ruth was saying in the morning, and kind of widening the canon, and not focusing so much on Roe versus Wade, evidently. And linked to that, I'm kind of thinking about from some of the conversations with some of you in the breaks about the role of the academy and the legal academy, and kind of comparative research projects tracking some of the anti-gender movement through the different legal academies, and particularly thinking, I mean, I'm just wondering, Ali might know if there's research done on the evangelical universities in the in Latin America, for example, or in the US in that respect. And I know that when we did some of the work on some of the key cases at the Inter-American Court, we were kind of tracking the conservative legal framing, training, and I think we need some more work to be done on that. It's because it's a long-term game plan. They didn't get here overnight, right? I mean, they've been playing this for a long time.
Thank you for that discussion. That was a really enlightening one. My question is regarding the statement made regarding this future thinking about where we can, get a home delivery of the abortion medicine, which is very futuristic coming from India. But my question is, how do you then make sure that the person has, without visiting a clinic, that the person is within that gestation 10 weeks period or not? And further to problematize it, is it like better when we're talking about, transnational abortion rights? So is it not better to not further classify the gestational period, because somewhere it is 12 weeks, somewhere it is 20 weeks, for the exception it is 24 weeks, and then to further classify into 10 weeks, what it comes to me is that we are further, making it more complicated instead of, amplifying sort of the bodily autonomy. So that's my question. Thank you.
Yeah, we'll take Maya, please. We'll take a last question and then we'll get the panel to respond.
Yeah, I was just going to come in about the way forward and ideas about self-abortion, and just give the example of the UK in addition to Norway, in terms of how particularly COVID, one of the huge things about what COVID did was both the Royal College of Obstetricians and Gynecologists in the UK and the midwives and the government allowed self-abortion to take place, in the sense that you get the pills, you get everything done, telehealth, teleabortion. And when that enabled that space, which now we are trying to contain, still to have. And I think, again, talking about, this is yesterday's discussion about, the pandemic and health governance, and sort of, so I think that is a really interesting kind of way forward, perhaps, and I wonder where Norway is in that context. I was also really interested in this notion of removing fetal viability completely as a kind of legal clause, and what are the options to push that, because that is, as you say, Mette, a sticking point. This whole notion of fetal liability. So those were just two quick questions, because I think there are two sides. We talk about, on the one hand, abortion is accessible when you medicalize it and you make it a health issue. And on the other hand, it is not accessible when you make it a human rights issue, or when you make, and I think these are, again, interesting entanglements that we need to sort of keep in mind as well when we think, how to strategize in terms of, and how to maybe gain over the anti-abortion activists. There's interesting work on Italy and on anti-abortion activism and in parts of Europe, and this is the work of Silvia Disordo's book, Fragmented Landscapes. So again, there is emerging work on this, and I think there can be that interesting intersection of knowledge and knowledge exchange between the northern and southern sort of work that's going on. Thanks very much.
Great. So can we just have very quick responses? Alicia, would you like to start, and then the rest of the panel?
Sure. I'll just say a few things. I couldn't agree more with what Rachel said about networks, long-term planning. Lynn Morgan has done really interesting work on the anti-movements and how they've operated in Latin America and the inter-American system in particular. As I tried to say initially in the talk, but I would reiterate some of the things that have been said, the Dobbs reasoning is quite particular to the United States. And over time, our court has not been very open to considering the reasoning of other courts. International law has made constitutional law, in my view, considerably more cosmopolitan. And I did an amicus brief on international and comparative law in this case. But I don't think that's the way this is going to exert its most powerful effects, as others have suggested. I think it's going to put a chill in terms of incorporating more progressive views, but the reasoning may be different. I would not draw a sharp dichotomy, Maya, between health and rights, because in the countries in Latin America where we've seen this green wave be so effective, the right to health and understanding the health system from a gender perspective has been critical to that enterprise. And I guess the third thing I have to say is about medication abortion, and I'll stop afterward, is, you know, of course, medication abortion is absolutely essential, and expanding access thereto through the mail with adequate, reliable information. But there will always be cases where pregnant people need to be attended at the health system. And we need to be very aware of that. In the United States, there's another wrinkle. The long-term Meta mentioned something about this. There are a lot of hospitals in this country where student and medical schools, but hospitals where people do residencies that either are now run by Catholic management like Caritas, etc., or in the clause where previously owned hospitals that were owned by the Catholic diocese and other Catholic organizations have been transferred to other private entities. The private contract law restricts the services that can be offered, the training that can be offered. So that is an important thing to keep in mind about training people and changing medical education. And I'll stop there.
I think just quickly, if anyone wants to add, we have any responses.
I thought I would have to answer the medical questions.
Yes, please.
Yeah. Clarification. Well, as it said, it's not a futuristic thing. It was happening during COVID. It's now. This is a treatment that, and multiple studies show that women are very accurate at knowing their the pregnancy length. Okay, that's why it's safe. I mean, there are multiple studies showing it's safe, and also WHO, they don't say that you need to have a medical examination to have an abortion. So that was that, and then it's a question of the viability of the fetus, and as a legal term. For one thing, if you look, well, only Western countries have registries and statistics on this, but if you look anywhere in the world, the law doesn't determine when women have abortion. It helps women not have illegal abortions. But if you pressure the law, and for instance, pressure viability too far down, you will start having illegal abortions because women who need them, they do them. And anywhere in the world you see that 92 to 97% of all abortions happen before 12 weeks, and only 2% after 17 weeks. So that's, women don't want to have late-term abortion and pressure viability. They want to have their abortions as early as possible. And if they have them later, it's either because in the States, for instance, they have a slightly higher limit amount after 12 weeks, because it costs money. It's hard to come by. It's not, they might have to travel. If you don't have to travel, if it's cheap, you will exit it early. That's what we've seen in Norway. After we got medical abortion, 84% happened before 9 weeks, 92% before 10 weeks. So you don't, it's not the law who regulates that. That's all the other things that you add, contraceptives that would lower abortion numbers, and also access that will lower the numbers. So, well, but take it out of the or viability out of the laws, or don't put them in. As the Australians said, it's a medical question. So the reason why they have set this limit between 20 to 24 weeks, depending on the states, is that after a certain limit in it's another health issue. I mean, the way you do it, the procedures, and the reasons why you might need an abortion are quite different after 20 weeks or 22 weeks. And that's why you need to have kind of a medical shift and maybe in the treatment. But it don't regulate when women need to have abortions.
I'll let you go.
Okay, we are beyond time, but if there's something last minute, you can just give a last word.
I'll just conclude by saying that power in the right hands dismantles emerging and pre-existing systems of inequalities. So we need to get into the spheres where decisions are being made so that we can have a say in how budgeting is done, how curriculum is the curriculum is going to be designed, and that is where the secret is. Thank you.
Thank you very much to a wonderful panel. Thank you.